students, I, Poonam Ingole, welcome you all to this pre-PhD coursework on Technology and Law, Contemporary Trends in India, organized by Postgraduate Teaching Department of Law, RTMLU, Nagpur, from 24th July 2023 to 5th of August 2023. Good afternoon, everyone. Today we are having Dr. Navi Vijay Shankar sir with us. May I introduce sir with your kind permission? Data protection and data governance consultant. Sir is a certified independent director. He is an information assurance consultant and presently works from Bangalore, India. He has a rich professional experience spanning nearly from 4 decades in the field of banking, financial services, advertising, and marketing, besides cyber law and education. Navi sir has also been in the forefront of netizen movement in India. He is the founder secretary of Cyber Society of India, founder trustee of International Institute of Information Technology Law, and founder chairman of Digital Society Foundation. Navi sir is also a visiting faculty in number of educational institutions and provides consultancy to various several companies. With this, I conclude sir's introduction. Now, sir would be speaking on the topic cybercrime related to person and property in India. If participants would have any kind of questions, kindly write in the chat box. Over to you, sir.
Yeah, good afternoon, friends. I understand all of you are aspiring for some kind of a research related to cyber crimes. Hopefully, this particular introductory session would help you to generate new thoughts and ideas. Of course, I would expect you to raise questions so that I will try to understand what exactly is your requirement. Otherwise, we will go through one structured presentation. So do you have any specific questions which you need to get clarified during this session? Anybody? I need to know what is your current level of understanding of cyber crimes and where do you want some kind of an emphasis? Any thoughts? Just 1 or 2 sentences from somebody?
Hello. Cyber frauds going on.
Yeah. Okay. Fine. Now, all of you have not, of course, chosen any PhD thesis subject, is it not? You have not yet chosen the topic?
Good afternoon, sir.
Few of them have chosen, few of them are yet to choose. They are newly enrolled for this PhD coursework.
Okay. Okay, good. So let us.
Sir and ma'am, Pragati Dhakne joined this session. Sir, my PhD topic is related to terrorism. I would like to get more knowledge about cyber attacks, related to modern technology. If you will guide, it will be helpful to me, sir.
Okay. I think we will be able to.
Thank you, sir.
Have only a very generic discussion in the available 1 hour. If you have any specific questions, we will discuss that. Okay, fine. Now, see, if you look at cyber crimes against persons and properties, before we go deep into it, let us first look at what exactly is cybercrime as a techno-legal perspective. Then we will straight go into some examples of cyber crimes, and around that we will discuss the technological issues and in terms of combating the cyber crime, what is the cyber laws which the government of India has introduced so far. So that is the structure. Okay. Now, the first thing we need to look at in terms of cyber crimes, say it is common in IPC to discuss crimes against property, crimes against person, crimes against women, something like that. When we come to cyber crimes, we must understand that there is no distinction between property and person per se as far as the technology is concerned, because data represents both a person as well as a property. We are in fact looking at the binary data, and sometimes actually it is a property only. Even my name on the digital space is my property actually. So only in certain cases there is an indirect impact on the man behind the identity. The identity itself is a property, whether it is a name or an email address or any other identity on the cyberspace, but there could be a man behind it, and in many cases the real identity of the person may not be available behind the digital identity of a person. In fact, one of the things which needs to be researched is if a person assumes a name different from his official name for, say, getting an email account or something like that and transacts, does it constitute impersonation? After all, if I register a Gmail account and say my name is Kumar or something like that and send an email to you, you may be perhaps thinking that one Mr. Kumar is writing to you. But if I am actually a Vijay Shankar, then the question is whether it is ethical and legally correct for me to transact with somebody under an assumed name. When we discuss many of the security requirements, including the privacy, pseudonymization is considered as a very important tactic of hiding one's identity, and it is considered a necessity from the cyber security point of view. But legally, the question remains unanswered whether it is proper for somebody to project as somebody else. There are divided opinions on this even in the judiciary. In fact, in one of the cases in USA, that Megan Mayer case, where some of you may be aware of, there was a 16-year-old schoolgirl who committed suicide because her Facebook friend, whom she thought was a 16-year-old boy, rejected her, saying that I will unfriend you or something like that. And because of that rejection, she committed suicide. It was later on found in the investigation that the so-called 16-year-old boy, who was known to this girl for about 2 months, was actually a mother of one of her classmates who had impersonated herself as a 16-year-old boy, befriended this girl, and subsequently dumped her just to teach her a lesson because she felt that she had insulted this lady's daughter, who was actually a classmate of this deceased girl. In that case, the police actually filed a case for impersonation, stating that this person registered on the Instagram under a different name, and then that was instrumental in committing the particular crime. But of course, in that particular case, the court did not approve of that. Then very recently, one of the Indian courts also made a mention that it is okay if somebody assumes a different name and transacts. That is, impersonation is okay as far as it is digital identity is concerned. I personally, I am not in favor of that kind of a particular thought process. In fact, Information Technology Act under two sections, section 66C and section 66D, does criminalize impersonation, digital impersonation. And how exactly that digital impersonation may happen may depend. Okay, like a person who is stealing a password and using the password is impersonating at the password level. A person who is just using an assumed name, if I perhaps put my name as the principal of your college and then send an email to you, that is impersonation of the email. And in the coming days, we will have impersonation with, say, morphed photograph, a morphed video, deep fake video, and so on. Whether it is proper for judiciary to give a kind of an approval for such impersonation, I personally don't consider it as wise. Okay, it is for people like you to debate further on this. So we were talking of the effect of an activity on the internet on the man behind the particular digital identity, which is a property. So if we look at the person as different from the digital identity, then in certain cases, for example, defamation of a email address, now is it an offense which can be recognized under, say, section 499 500 of the IPC is a question. Unless something touches a physical person, you cannot invoke the IPC. So therefore, the need to have a kind of an understanding of the person behind a digital property is essential to say comment on crimes. In fact, in metaverse scenario, people actually assume an avatar. The avatar will not only be a name they give to themselves, but also to age profile, gender profile, or anything else. Okay. So when a person like that actually interacts with another metaverse character on the metaverse scenario, the question of whether it amounts to impersonation and other things needs to be debated. All of you are aware that recently there was also a case filed in India only, where a metaverse character was accused of having harassed another lady metaverse character. Now, when this sort of a thing happens, when one metaverse male character, let us say, misbehaves with a metaverse female character, does it amount to a cyber crime or does it amount to an IPC related crime? And whether you should consider that the two physical persons behind these two avatars are the characters who have a litigation kind of a thing is something which we need to debate. So that is one of the reasons why I feel that we have to keep the virtual space different, physical space different. In case a person has got a virtual identity, something wrong happens to the virtual identity, that should be settled in the virtual space itself. And unless it is disclosed that this virtual identity belongs to a particular person, there is no need to actually make it a cross, say, society crime, like a crime in cyber society affecting a physical person. So this philosophy of how to look at virtual space in terms of crime is something which requires some further research. But ultimately, a digital person or a digital property, they all represent just a binary sequence and nothing more than that binary sequence. Now, when we say a property is a binary sequence, humans actually don't understand or experience the binary sequence. If I give you a series of zeros and ones, you really don't understand what it is. But in practice, what happens, the binary sequence gets converted into human experience by a set of devices which we choose. Say, if I have got an electronic document, and I put it on a Windows computer and it displays a PowerPoint presentation, I am experiencing the text face of that binary. So there I am using a computer which is loaded with say Windows, which is also loaded with an application called PowerPoint, and a combination of this can convert the binary sequence into a PowerPoint presentation. If there is a voice there, perhaps you need a speaker. So these various intermediary computing devices enable us to convert a binary sequence into a human experienceable kind of a situation. Now that can be a text, it can be a sound, it can be a image, which is very common, but it is also possible that if you are having the right kind of devices, definitely you can actually have a sense of touch, which is what you are seeing in the picture in the virtual reality case. This person is wearing a glove which is connected to various wires, which means that if she moves her finger, it is being converted into a digital activity on the virtual space. So sense of touch can be initiated through appropriate devices. Similarly, in future, you will be able to have a sense of smell, sense of say taste also. How? Maybe today if you want to print, you need an ink cartridge. So digital information is fed into the printer, it invokes a particular colored ink and then it converts it into an image. Same way, there will be certain gadgets which will emit smell of a particular nature with appropriate trigger. So smell can be experienced. Similarly, perhaps taste also can be experienced. Remember that today computer research has gone to an extent whereby a computer interface can directly interface with human brain. So it is possible to have an interface which, if I am say wearing it like a helmet, it can trigger a taste, smell or anything directly interacting with my brain. So these are all human experiences generated by digital documents. The digital document still remains zeros and ones, and it is the humans who try to convert it into an experienceable, you can say, document. And even here, we need to remember that technology can only translate it into a particular level, but understanding something as something is again a human character. For example, if you say NAAVI, now whether you should interpret it as the name of Vijay Shankar on the web space, he is also called Navi or something like that, is something which happens because you have some additional knowledge that this person, there is a person in India called Navi. His name may be different, but he is known as Navi. This is a prior information if you have got, and therefore when somebody says NAAVI, you say, oh, this is Navi. You may read it as Navi, you may perceive it as Navi. Now that understanding comes from the human who is interacting. If there is another person who doesn't know Navi, for him NAAVI is just a alphabet stream. At best, he may say that it is something connected with Avatar film or something like that. He may misunderstand or he may not understand it. So a digital document gets the meaning ascribed to by the human being. That is why in what I have called as my theory of data, I say that data is created by technology but interpreted by humans. You take out the human understanding, the data can be anything. So human involvement in interpretation of data is very important, and so when we are talking of crimes, this becomes essential. That is why in Indian law, in the Evidence Act, we have got something called Section 65B of Indian Evidence Act. I'm not sure whether you have heard about it, otherwise you should read more about Section 65B. Under Section 65B of Indian Evidence Act, it says that every electronic document presented in a court of law becomes admissible only if it is certified by a human being saying that this electronic document, I have viewed it through a certain process, and at the end of this process, this is what I think it is. So a human being interprets the electronic documents, gives a certificate that when I viewed this document in my computer using a particular operating system, etc., I saw something on my screen. I took a printout of that, and I am now signing and giving you a certified copy that this is what I saw when I viewed the electronic document. So this is actually dependent on the person. So somebody may say, this is what Vijay Shankar saw, but when I saw the electronic document, same electronic document, it was different. It is possible. For example, if you look at a website, from say Nagpur against another person who looks at the same website, say from Australia, Sydney, the two people will look at this page which may be different. It may be different for different reasons, maybe because when you come from Nagpur, maybe some advertisement related to India may be present there. And when you come from Australia, something else may be there. So therefore, the web page is constructed dynamically in real time based on the person who is viewing it. Therefore, the electronic document, something called www.so-and-so, could look different to me and different to you. That is why Section 65B certification is necessary even to accept a normal web page as evidence. Many of the courts are not aware of this. They think that Section 65B is like a notary certificate. It is a wrong perception. It took nearly, say, 12 years for the Supreme Court to understand and come up with the clarification. Remember, the first time Section 65B certificate was used in a court of law was in Chennai, the Suhas case, which was the first case which went into conviction. And I happened to be the person who actually presented the Section 65B evidence for the first time in the country. That was in 2004. Then 2012, this Anwar versus Bashir case happened, and Supreme Court said that Section 65B certificate is mandatory, kind of a thing. Even subsequently, many people in the judiciary are still arguing that Section 65B certificate should not be there. It should not be made mandatory and so on, because they don't understand this thought, which I have called as the first hypothesis of this theory of data, that data is not absolute. Data is created by technology, but it is interpreted by a human using many devices. If I choose a different device, my interpretation will be different. If I am using a language interpreter which is not English, when I click on the button A, it may give some other kind of letter on the screen. So there is any questions? Okay. So there is dependency to interpret electronic documents, and if this is there even for an ordinary electronic document, you can imagine if you want to dub something as a crime, you must be able to also understand that first of all I should know that it is a crime, and then this complexities of data, evidence, everything is there. Now, when a technical person looks at something and calls it as a crime, he may use the words like hacking, malware attack, social engineering, stalking, and so on. We also sometimes have infringement of IPR, like copyright, patent, or trademark. Then we have got social media related crimes, then deepfake videos, and latest we are also talking of privacy infringement. These are all the technology terms used in describing cyber crimes. Now, if you look at the legal perspective, we don't have to necessarily use the same terminology as technology people use it, because technology people have a fancy of creating some kind of name every time they want to present something new. For example, ransomware is nothing but extortion. Okay, but in 2000, when this act was passed, nobody knew ransomware. And ransomware as a kind of say crime was not in existence. But we can today apply the ITA 2000 drafted in 1998 to 2000 era for the ransomware, by interpreting that the activity of a ransomware is denial of access, is modification of the electronic document, and extorting money. Now, extortion of money is an IPC crime. Okay. Then modification of an electronic document is a crime under Information Technology Act. It may come under section 66. Denial of access because it is encrypted will also come under section 66. So section 66 addresses the crime called ransomware along with a section of IPC. Now, this is how the law will interpret, whereas technology people would like to have a name for everything. So when we look at cybercrime from the perspective of law, okay, now law gives a definition. Now technology doesn't give a definition. Okay, so if you want to give relative importance, the definition under law should be considered as more acceptable because that will stand in a court of law. So under our current system of cyber laws in place, I would like to define a cybercrime as any contravention of law. Say, for something to be called as a crime, there should be a law and there should be a contravention of the law. Maybe you can call something as ethics, and breaking the ethics could be considered as a attempt to commit a crime or something like that. But really a crime is one which is defined as not to be done in a law. So a contravention of law which results in an adverse consequence to whom? I am saying to an electronic document. But many times we say that cyber crime is an offense or contravention of law where a computer is a tool of crime or a target of crime. This is one of the common definitions used by technology people and also endorsed first by the FBI, which defined the cyber crime as an offense in which a computer is a tool of crime or an object of crime. I am trying to say that that definition itself needs modification. We have to look at the electronic document as either the tool of the crime or target of the crime to define some action as a cyber crime. And if you really want to look at it from the legal perspective, it should be a contravention of law. Okay, so a contravention of law that results in an adverse consequence to an electronic document is what I call as cyber crime. And in law, we treat certain things as civil wrongs and certain things are criminal offenses. And you know that civil wrongs means a contravention in which leads to one person claiming some compensation from the person who caused the wrongful loss. Whereas in criminal offenses, the state will prosecute against the person who caused some kind of a damage, and it may lead to the imprisonment of the perpetrator of the offense and also a fine which goes to the state. In the case of civil wrongs, the compensation comes to the person who has suffered the wrongful loss. In the case of criminal offense, the fine goes to the government. So these are the two kinds of remedies which we see for cyber crimes. Now, in India, we have this law called the Information Technology Act, which was first enacted as a draft law. It came in 1998. It was called E-Commerce Act 1998. Then it became in IT Bill, Information Technology Bill 1999, and then it became the law Information Technology Act 2000. Then in 2008, a major amendment was made, and today we are 23 years from the original date of this particular law, which became effective on 17th October 2000. And the government is now contemplating on a wholesale revision of this particular law and wants to introduce a law which may be called Digital India Act, DIA. We are still awaiting more details. Some initial details are there, but maybe before the end of this month or before the end of this parliamentary session, a copy of a draft copy of DIA may be presented in the parliament, or it may be published outside along with the copy of the data protection bill, which may be placed in the parliament for discussion and passing. DIA has not reached that stage, but DIA draft may be presented for public consultation within the next 15 days. So if you look at this Information Technology Act, it has got one chapter called Chapter 9, which talks about the civil wrongs, which lists certain contraventions. Chapter 11 talks about offences where certain crimes are specified. Now, in Chapter 9, the most important section is Section 43, which is actually a combination of 10 subsections, which says that if any person without the authority of the owner of a computer system accesses the computer, when you say computer, it includes computer, data, the network, and all those things, okay, a system, okay. So unauthorized access to the system is a contravention of Section 43. Unauthorized downloading, introduction of a virus. In fact, virus is used by a more common name called computer contaminant. So a computer contaminant, virus is also a computer contaminant, but the computer contaminant is a broader word. Something which is not expected to be there in the computer is a computer contaminant. So if there is a adware, that is something which provides advertisements when I'm browsing something, and that comes as a software which lies in my system, then that is a computer contaminant. Even a cookie is a computer contaminant if it is unauthorizedly put in my particular computer. Therefore, ITA 2000 has by definition has added this concept of consent, which we normally use in the privacy area. Unauthorized damaging of a computer, unauthorized disruption of a computer system, unauthorized denial of access, they are all offenses or say contraventions under Section 43. Then providing assistance to another person for contravening the law is also an offense. In fact, you must have heard of the historically important case called Umashankar versus ICICI Bank. Okay, yes, Umashankar versus ICICI Bank was a historical case, just as Suhas Katti was the first case in which a conviction happened under Information Technology Act. Umashankar's case was the first time when a bank was asked to bear the liability for a phishing loss, particularly when the victim had admitted that he had answered the phishing mail and given away his password. Despite that, we argued this particular case through multiple levels of judiciary. In fact, I argued this case as a power of attorney holder of Mr. Umashankar. We first got a favorable verdict in the adjudicator's office in Tamil Nadu, and then with the TDSAT, which is the appellate tribunal, and then ICICI Bank went for the third time in appeal to Madras High Court. Madras High Court also rejected that appeal. So after that, now ICICI Bank has started releasing the money. So the case has come to some kind of a conclusion after 14 years of hard fought battle. In this particular case, the TDSAT made a mention of this Section 43 subsection G about providing assistance, and it said that the negligence which was shown by ICICI Bank in terms of not providing whatever you can call as reasonable security measures should be considered as providing assistance to the fraudster. Like, suppose you are safeguarding an inventory in a godown and you keep the windows open so that the thief can come into the go down and steal something, then that is negligence of the caretaker. And like that, the court said that ICICI Bank was negligent in providing security, and that we consider as a contravention under section 43 subsection G as providing assistance. Therefore, ICICI Bank was held liable to pay the compensation, though there was another, perhaps a third party fraudster who had really taken the money. ICICI Bank was a conduit, it was an intermediary, but they had to pay the money. Similarly, there is the provision called charging of service. That is, if somebody uses any service in the internet and charges it to somebody else, that is an offense under or a contravention under section 43 under this charging of service to another person. Then there is something called diminishing the value of information residing inside a computer, which is again a very generic description, which may include even privacy laws and other things, confidentiality laws. That also is coming under section 43, destroying the computer source code. Okay, now section 43 basically is a civil wrong section. However, section 43 is used to define an offense under chapter 11 called section 66, which says that any contravention under section 43, if it is done with malicious intention, it will be considered as a punishable offense under section 66, which will have 3 years imprisonment. So section 43 not only defines a civil contravention in which compensation can be claimed, but also defines a cyber crime which is punishable by the prosecution. Now, the court for deciding about the section 43 related issues is called the adjudicating officer. Powers are given to the adjudicating officer under section 46. He is the IT secretary of every state. Appeal from him goes to the appellate tribunal. Today, the appellate tribunal is TDSAT, which is Telecom Disputes Appellate Tribunal. And from there, further appeal comes to the High Court. That is what happened in the case of Umashankar's case. And if it had not been settled in High Court, it would have gone to Supreme Court. So section 43 is a very comprehensive section, which is both a civil wrong as well as a criminal offense. There is a section 43 capital A which was introduced in the 2008 amendments. This was not there in when Umashankar's case happened. That is, the cause of action of Umashankar's case happened in the year 2008. Prior to this November, actually 2008 amendments were made in December 2008 by the Parliament, and actually they became actually effective only in October 2009. So therefore, on the date of Umashankar's fraud, 43 capital A was not there, but now it is there. What 43 capital A says is that if there is a company and that company is handling what is called sensitive personal information, then they are expected to follow what we can call as reasonable security practice. Now, if not, then they will be liable to pay the damages. So there is a definition of sensitive personal information. This is applicable to body corporates, not to others. And there is a need for something called reasonable security practice. And subsequently in the year 2011, government actually came up with a notification to explain what is a reasonable security practice. And it actually is the industry best practices, various requirements. Sometimes we use say frameworks like ISO and other things. So those are things which on a case-to-case basis court should decide that there was reasonable security or not. If there is no reasonable security, then this bank or the body corporate becomes liable irrespective of the real culprit, and once they compensate the victim, they can go back and try to trace the real victim and then the real culprit and then recover the money out of it. For example, if ICICI Bank has paid money to Umashankar, it doesn't mean that ICICI Bank has to live with that loss. They can go and find out the person who has committed the actual crime, who is a customer of, in that case it was ICICI Bank only, otherwise some other bank, because money cannot go from one bank and vanish in air. It has to go to another bank. Whether you use UPI, whether you use any internet banking, NEFT, it has to land in another bank account. And therefore, the fraudster will have to have an account with a bank with whatever KYC responsibilities are there. Therefore, that bank should be held responsible. In the Umashankar's case, both the paying banker and the collecting banker were also ICICI Bank because it was two branches of the same bank. But in other cases, it may be different banks. So this is how the section 43A expects reasonable security. Now, when the reasonable security practice was defined, to some extent this is also linked to another section called section 79, where due diligence has been defined. Due diligence is an important concept, which is the expected best practices which any organization has to follow in order to prevent occurrence of cyber crimes. This includes, so this section 43 capital A, notification of reasonable security practice, includes all the privacy related issue, like you can't collect information without consent, and minimal collection, minimal retention, and all those things. So whatever we talk of the data protection bill today, everything is available under section 43 capital A. This is the beauty of what ITA 2000. Now, if we come to the criminal offences, there are several sections starting from section 65 up to section 74, approximately about 20 plus sections, because some sections have got subsections, capital A, capital B, like that. Now, section 65 as well as something called section 67C works with the need for protection of evidence. That is, evidence should not be destroyed. That is the objective. So section 67C talks about the retention for certain period, and section 65 says that if something is destroyed before a normal retention period, it becomes an offense with 3 years of punishment. Now, other than this, section 66, which is also located associated with section 43, defines basically the list of things which call themselves a cybercrime. Then 72 capital A, they are all data related offenses. Then there are several sections which are related to obscenity, 66 capital E, 67, 67A, 67B. Then offenses related to digital signatures, which is 66C, D, 68, 71, 73, 74. I'm not going into the details of this. Please look at it separately. If you want, you can refer to one of my e-books on cyber crimes. If you go to naavi.org, naavi.org, you will get most of these details. Then there is offenses related to stolen systems, 66 capital B, 66 capital F, and 70. They actually, 66 capital F is actually titled as cyber terrorism. Okay, this is one case which talks about cyber terrorism, but what it means is for something to be called a cyber terrorism, one, the effect of that should be to say cause loss of life. Loss of life happens when a bomb is exploded by a trigger of a mobile or something like that. See, if it's a normal bomb explosion, it will come under your IPC. Now here we are talking of an electronic detonation of a bomb causing loss of device. It may become part of section 66F. Other than that, a virus introduction and other things also may come under this, in case the effect of that is to create some kind of a disstability of the society. So if there is a large scale fear caused in the society, that is recognized as a terrorist activity. Terrorist activity, one end result is the loss of life. Second is, suppose there is a series of attacks on several banks in India at the same time, then the community gets a sort of a fear about the banking system in India, that is causing terror. So there are certain things you can look at that section 66F. Section 70 is a definition of a protected system in which the government has got the power to take over the security of organizations. Recently it has been used for declaring many of the banking systems as protected systems, and once it is declared, the security becomes the goal of comes under the monitoring of CERT-in. Okay, there is also abetment and assistance under section 84B and 84C. Abetment and assistance involves the total punishment as meant for the particular section. Attempt normally has got a 50% punishment. Okay, so there is a series of 20 plus sections which you can look at it separately. Now, just we'll quickly go through some examples just to give you an idea of how these crimes actually manifest in the normal place. First is what we call as phishing. Phishing is can happen both by impersonation of email. It can also happen by impersonation of a website. For example, Umashankar's case was a phishing email where the fraudster sent an email in the name of customercare@icicibank.com, and therefore the person gave away his password, whatever is that. That's a very common aspect. There are also cases where the website itself is impersonated. For example, this website which is there on the line 1 actually is not icicibank.com. It is actually iclci.com, or it can be IC1CI. By manipulating the digits, it is made to appear like something else. This can be done for Axis Bank also, where I is there, and sometimes A also is often used for such impersonation. Beyond this, there was one case in which there was something called cgtmse.in, and there was a website called cgtmse-govt.in. A fraud was committed by using the cgtmse-government.govt.in as if it is a government website, and frauds to the extent of several crores might have been done through this. Actually, there was a department called CGTMSE in the government, and they were using the domain name cgtmse.in, but the fraudster used cgtmse-govt.in and committed the fraud. So this is impersonation of the website. Then in case of ransom, where normally what will happen is a virus kind of thing will come into the computer, it will encrypt the files, and then a kind of a notice appears saying that if you want to decrypt your information, you need to pay me, say, 2 bitcoins, 3 bitcoins, or whatever is that. That is the extortion. So in this extortion, what happens is, first of all, unauthorized access is gained by the fraudster. He manipulates the files by encrypting them, and then he denies access to the legitimate users and then asks for money. Sometimes in the current generation of ransomware, they also take this information outside. That is called exfiltration of data, which is perhaps sold on the dark web, or at least it is used as a threat to the company, saying that it is not only that we have blocked your data, which perhaps you may think of getting it back from your backup or something. We also have a copy of your sensitive information, which we will release to the dark web, which will cause reputation loss and other problems. So that is how today's ransomware also exfiltrate the data and use it in a different way. Now, there was another case of a university web server having been hacked by a hacker who actually posted some of his personal web pages on this university website, and from there he was running a spam kind of an activity. Why he perhaps did it? You know that many of the organizations have a whitelist and blacklist of websites to be visited. If it is a university site, all the employees are allowed to enter the university website, or if an email comes from that university website, it will normally be allowed by the security system. So the fraudster actually went into a legitimate, respectable say domain, and then created a separate folder for himself and created malicious activities from within that. This is another kind of cyber crime. You can see how many multiple types of crimes are involved in that one instance. You must have also heard of something called steganography. Steganography is a technology where if there is an image, within the binary sequence which describes an image, a certain text message is also embedded. When you say embedded, it means that after all, the text message also is a binary. Image is also a binary, except that the image is several MB file, whereas the text is only some few bytes. So out of my say 10 MB image file, I can run an algorithm to say pick 0 from here, 1 from here, 1 from here, or something like that, and create a text information. And that is how steganography as a technology hides a smaller file in a bigger file, and the bigger file is what is being seen, and behind that there could be text files. There have been instances of this used by terrorists in some places. So if you are having a website, if an organization is maintaining a website and we are posting a lot of the pictures there, we should also ensure that our own pictures are not downloaded by the fraudster, modified with the steganographic information and re-uploaded onto the website so that it gets spread. That is how the terrorists misuse a respected website. Now, sometimes cyber crimes happen through devices like, say, your CCTV cameras. What CCTV cameras do, they take a picture, maybe a video, and stream it into a server. The file size of videos are large. And what hackers can do is to divert the incoming, say, streams to a server and cause what we call as a denial of access, make the server crash. So this is a common problem with the industries sometimes feel. Sometimes we also have people using what we call as a dropped pen drive attack, which is a pen drive is just left in an organization's premises, say in the parking lot or something like that, with a virus. Somebody picks it up, thinks that some of the employees must have lost it, will take it and then try to put it inside the network just to find out whose pen drive is that, and that is how virus gets spread. Then sometimes in the ATMs we have this introduction of an external device which is fixed on the ATM so that it can scan the card when it is inserted. Same time, skimmers which are handheld are also used. These are all gadgets which are used for stealing information. And these are also sometimes used in OEM devices like this POS machines where the chips are altered and a additional chip is put in with malicious code. Such chips are called Manchurian chips. In fact, the crimes have been so sophisticated that in one particular case, a Manchurian chip which was as small as a grain of say rice was inserted into the motherboard of a computer. You know that motherboards of a computer is done at very sophisticated factories. So which means that this particular insertion was done at a factory and it was used by a very sophisticated and a well-informed organization called Amazon. So Amazon bought some computers and those computers came with motherboards with this Manchurian chips which was stealing the data and sending it to China. So that is why we say that sometimes security people will say that you have to verify the source from which you buy hardware and software. You also have heard of NFC, that is near field communication, where up to 5,000 rupees you can transfer money without swiping a card or without giving your OTP or something like that. This is also used by criminals to just steal the money. Then you have heard of Nigerian frauds. People have lost money and some of them have committed suicide. So it becomes an abetment to suicide kind of a thing. In addition, we have got a lot of financial crimes like the PNB case where 11,500 crores were lost. Bank of Bangladesh case where $81 million or something was lost. Bank of Muscat, which was a credit card fraud. SBI credit card fraud where the ATM was compromised. Then UPI fraud of Bank of Maharashtra where without debiting the account money was paid. So there are multiple cases. It may not be possible for us to go through all the cases, but many of these are phishing cases. The question we have to ask ourselves is how do we defend? Cyber security is what is meant to be maintained, and today that is a legal requirement. And if security is not there, there can be liability to the organization. So that is what we need to remember. So I think I will stop here, and if there are any questions, we will take it for a couple of minutes. You have to unmute yourself and speak.
Sir, may I read some questions are there in that box?
Yeah, please do that.
Just a minute, sir.
I am not seeing that, so please read it out.
Yes, sir, just a minute. So the first question is from Vinay Borkar, sir.
Yeah.
He has heard about the news about the sextortion which he has come across in many of the villages like Rajasthan, where the sextortion has taken place, and some people have caught over the people who have uploaded the FB and on FB and social media regarding the sex video calls and all. So he expects the some suggestions and answer from you, sir, that if such thing happens, so what are the remedies available with those people who are the victims, and do we have some cyber cell mechanism to prevent such sextortion on social media?
See, prevention is one thing, and then responding to the event is another thing. Okay. How does this happen? This is basically an extortion. Okay. Extortion happens because somebody catches hold of a photograph which is available in Facebook or something like that, and then morphs it and then tries to send it as if it is a nude photograph of this particular person or something like that. And the recipients may not be able to distinguish. This is where the latest technology of deepfake and other things make it even more difficult, because even a video can be completely morphed. Okay. So when that happens, it is left to the character of the individual to be able to withstand this social stigma, and for the people surrounding the person to actually support that person. And in fact, I am reminded of a case in Salem where a girl committed suicide because of two things. One, she felt that cybercrime people were taking too long a time to sort out. She had given a complaint, and then she felt that her own parents are not supporting her. Okay, one of the boyfriends had marked her photograph and sent it through WhatsApp saying that these are nude photographs of this girl or something like that. At least the parents should have been able to understand that my daughter is not of that type. That girl didn't get that support, and she committed suicide. So the society is responsible for that to some extent. So punishing this person is a different issue. It can happen. It can happen even a year after the crime. But in the case where a person has committed suicide, there is no point in punishing this person after 2 years. It is not a full-fledged remedy. So society has to understand that nothing is trustworthy on the internet. Today we talk of fake news. Why? Because we know that every news item which comes on the internet, on WhatsApp, you have to check it whether it's correct or incorrect. Similarly, if I get a photograph or something like that, it should be considered as it is false or something like that. Anybody can fix you. If I don't like you, see, it has happened in employment scenarios. If I don't want somebody to be promoted, there are people who have sent wrong, say, videos or pictures of that particular person to the bosses just to prevent that particular person, boy or girl, to not to get promotion. So these things do happen. And prevention, basically, you should not make your photograph available to these people. So that is very difficult because everyone is having a Facebook profile, Instagram profile, and if you accept any friend, then everybody else got our photographs. So can I say that my photograph is not available? If you make a Google search, you will get tens of my photographs. So if somebody wants to morph it, I cannot prevent that. But it is possible that the recipients of such messages, they should know that these are frauds which keep happening. So I should not jump to conclusions and make fun of people. So there is a need for the society to change more than anything else. Okay. That's what I want to say about extortion. But I have come across several situations where people have voluntarily given away money on certain dating apps and other things. That is a self-committed crime. Okay. Anyway, recently I came across a person who paid 4.5 lakhs for a proposed meeting with a girl on the dating app, which I feel that there was a complete scam. Okay, there was no such girl. There was no such arrangement, but this fellow ended up paying 4.5 lakhs in Bangalore. Okay, now that is Swayam Krutaparada, we say. Okay, self-committed, this thing, very difficult to prevent. Okay, then next question.
So next question is from Priyank Shukla. He says that as we see the legislation is scattered and there is no presence of a single comprehensive legislation, is it not the need of the hour to prepare a separate penal provision dealing with the offences in the digital world?
Now, the Information Technology Act is a single legislation which addresses all offences related to electronic documents. If there is any other offence committed under IPC with electronic documents, the cause of action being IPC, it will be booked under IPC, evidence will be produced under digital evidence. Okay, so otherwise there is a central law, and so that is not an issue. Okay, and in fact, in the upcoming DIA, Digital India Act, it is possible that this chapter 11 of ITA 2000, which has all the criminal sections, it may be totally shifted to a chapter in IPC, so that ITA 2000 will only deal with civil wrongs. Criminal offences will go to the IPC. So then that will be another system where all cyber crimes and other crimes will be handled by IPC, whereas civil wrongs related to adjudication, etc., will continue to remain in ITA 2000. Okay. So Priyank Shukla, you please go through ITA 2000 in full. It is there. Okay. How to avoid hacking of the bank accounts? Okay. You have to keep your password secure. That is one thing. But there are many times viruses which actually steal your password without your knowing. If you click on some malicious link or something like that, a virus will steal it, so you will not perhaps know. All phishing are not cases where you give away the password, but there are phishing, that is somebody makes a phone call, makes you believe that he is a genuine bank employee and asks for your OTP. Such things also happen. This is called social engineering. Okay, so we should not fall prey to it. Of course, it is easy for me to say don't fall prey to it, but these fraudsters are so intelligent and they speak so well that even educated people sometimes fall prey to it. Yeah. What is drug trafficking? Yeah. Drug trafficking is an offense under drug trafficking. If it is done through website, if it is done through email, then you combine it with electronic offenses and try to book a case. Offenses are still under the original act. Okay. Fine. I think we have exceeded our session time. Yeah.
I hope no more questions are there. If anybody is having any question, kindly unmute yourself and kindly ask, sir. No questions? Okay.
Okay,
I
please go
would-
to navi.org and you may get a lot of ideas on where to research. If you are doing research related to cyber crimes, cyber forensics, science.
Hello, ma'am.
Yeah.
Hello.
Yeah. Okay. Yes, go ahead.
Okay, sir. Now I would like to
Thank you, sir.
propose a formal vote of thanks, sir.
Yeah, please.
Okay. Thank you, sir, for being so nice to us and enlightening us with your very expertise knowledge on behalf of Postgraduate Teaching Department of Law, RTMNU. I would like to extend my heartfelt gratitude to the esteemed guest, Dr. Navi, sir, and his informational session today, who has much enlightened us on the digital activity on virtual space, effect of activities in cyber space, concept of digital property, with specifically emphasizing on section 43 and section 65B. Thank you, sir, for your valuable time. We are looking forward for more such sessions with you. Thank you so much, sir.
Okay, thank you.